Okay, listen. You need to talk with your attorney about that.
Your Honor, I have.
Do you listen to your attorney as well as you're listening to me? That means not at all.
I got mental issues that just like I'm overwhelmed, very much so, Your Honor, but go ahead.
Thank you. Talk to your attorney about these issues. He'll talk to the prosecutor. They'll see what can possibly be worked out, if anything can be worked out. I'm not reinstating your phone privileges. You violated that condition of bond. That will continue revoked. Okay.
Hello, guys, and welcome back to the channel. Today, we are going to see a court case Judge Simpson shuts down annoying big mouth defendant. So let's watch it together.
Good afternoon, Your Honor.
Good afternoon.
Joe Smith. Hands in your pocket.
I'd be asking to adjourn the probable cause conference 2 to 3 weeks. I'm still, there's still some discovery that's outstanding. I'm told that the prosecutor has that. I should have it very soon. And I would ask to address the condition of bond.
Probable cause conference, October 17th, 2024, 9 a.m. Yes, that's the bond.
My client is a football player at Community Christian College. And he has, I think, 6 games left in the season. One of those games is in Atlanta, Georgia. One is in New York City. So I'd be asking for the court's permission for him to leave the state to travel to those games. Additionally, I'd be asking for the court to allow either the scram tether to be removed Friday before and then put back on Monday with an ETG test.
What's he been doing all season?
He hasn't been playing.
So what is he? Is he set to play these games? I guess I'm trying to figure out what changed.
He's been getting me documentation to verify that he's on the team. So I wouldn't make the motion to amend his bond until I was given at least some verification. So he's presented me with his class schedule, with his school ID, his screenshots from his the computer system that they use to communicate with the rest of the team, his schedule, his recruitment information. So now that I have that, I was comfortable making the motion.
I guess I'm just trying to figure out. He's on the team. Could have had that to you at any point in time. Hasn't been playing. What is now causing him to play now?
Well, we're asking. I don't understand the question, Judge. We're asking now because now I have the information to ask. He asked me about this weeks ago. I didn't have the verification. So he's been asking for permission to play. I wouldn't bring it to the court until I had independent verification.
So he sat out, what, 4 weeks, 5 weeks of the season. Has 6 weeks left. And now is going to play. That's what I'm getting at.
That's up, whether he's going to play or not is up to his coach. But I'm asking the court for permission so that he can be eligible to do that.
Okay.
Can I respond, Your Honor?
Yeah, go ahead.
Thank you, Your Honor. As the court can see from the phone, this is an OWI causing death case, so it appears to the people that the defendant is at liberty at all and has a scram tether is frankly quite a gift, given the facts of the case and the circumstances surrounding it. Your Honor, the people are opposed to any removal of that scram tether at this time. It does not seem appropriate to allow the defendant to do that. We would ask the court to deny this request. I just was able to receive the MSP lab report, and I just showed it to defense counsel after this case was called, so he hasn't had the opportunity to discuss it with his client yet. But the people are now able to tell the court that the MSP lab report reflects that the defendant's VAC at the time of the crash and death was 0.186.
Oh, so he sat out half the season, but now that court restrictions are in the way, it's suddenly game time. How convenient. The judge is just asking obvious. Why now, meanwhile, the prosecution's dropping BAC levels like plot twists, and we're debating if a tether is more important than a life great priorities.
I'm trying to understand. If I'm the coach of a team, I got a player, hasn't played half the season. Something has to change that says now this person is going to play. Not just that he provided the information regarding that to counsel.
Which it's my understanding he's been eligible to play as far as his coach is concerned the entire time. What he needs is the court's permission. I believe he has been practicing. Is that correct? Have you played in any home games?
Yes.
So he has played. He just hasn't been able to travel. So at the very least, Judge, if the court's unwilling to remove the tether, I would at least ask if the court would allow him permission to leave the state for, there are actually 3 out-of-state games. There is one this coming weekend in South Carolina.
I may allow him to leave the state. I'm not removing the tether. I may allow him to leave the state, but I'm going to have to see a schedule. So understand this. I'm going to deny the motion. However, counsel, I would allow him to leave the state to play.
Judge, I can show the court a copy of the schedule right now.
I'm not going to do it right now. Prepare me an order with the dates that he's leaving. Get prosecutor to stipulate to those being the dates on the football schedule, and the court will sign off.
Thank you.
Minutes or adjourn date.
17th. Thank you.
Thank you. Have a good day, Your Honor.
Call the case. People versus Dolores Strickland. Yeah, relax. Go ahead, have a seat.
Ready, Judge. Torshell Feaster, Assistant Public Defender, appearing on behalf of Ms. Dolores Strickland. Ms. Strickland, please state your name for the record.
230 times Dolores Strickland.
Thank you, Judge. I have had many conversations with Ms. Strickland, and we were working with the people, with Ms. Tanner, to try to resolve this matter. Ms. Strickland had a particular offer she wanted requested. I asked Ms. Tanner for that.
You asked?
Ms. Tanner.
How'd that go?
She was not willing to give Ms. Strickland the offer that she wanted. Then I sent Ms. Tanha the mitigation letter just to make sure she had it, because Ms. Strickland wanted you to have it and Ms. Tanner to have it. I told her this was not the point for Your Honor to have a mitigation letter, but I did make sure Ms. Tanha had it. And you're asking for another adjournment so Ms. Tanha can consider the offer in light of the mitigation letter that I have made sure she had per Ms. Strickland's request.
So, do we have the...
And also, can we do that as soon as possible? Because I've been in here, Your Honor, 230 days today, and I've got absolutely nowhere. And I also sent you the mitigation letter and a letter in the mail just recently. So you'll probably get that too.
Okay. I know you've been in a while, but I also have 3 cases. So that may be part of the problem.
Altogether, from what I understand.
If I might, Judge, Ms. Strickland is hoping for a resolution that will not include any type of probation.
Oh.
And that is not what is being offered at this time. And that is going to possibly be a hang-up to resolve this matter.
And Your Honor, I told him that I would maybe consider it. It depends on how long it would be. But however, I do have family in Florida, that Tallahassee, the hurricane, things like that I really need to get out to see if they're even alive or what happened to them, because I can't find nothing out in here. And I talk to them through Messenger. That's the way I stay in touch with my family. And I know they got hit. I just don't know how hard. And I can't get no information because the only person that I have here is my ex of 15 years and my other kids that, I don't have their number right now either, because I cannot get to their number, and I do not have phone, which I need to ask
The courtroom drama continues. We've got a defendant counting every single day behind bars like it's a hostage situation, a mitigation letter that's apparently floating through the postal system, and a sudden urgent need to check on distant family. Just as probation becomes an issue, meanwhile, the judge, who's juggling multiple cases, is somehow supposed to magically resolve everything instantly. But sure, let's pretend the real problem here is the system, not the stalling selective urgency or the ever-changing story classic.
Your Honor, can I get my phone privileges back on, please?
I believe they were restricted because she had contacted.
Because she violated a condition of bond, so I revoked it.
Correction.
I was already punished for that, Your Honor, because he had them block his number. So that should have no problem of me calling my brother and trying to get help from him, or contact him, because that's who I was contacting. I wasn't contacting my ex.
Okay, Ms. Strickland. Now, a lot of these requests that you're making,
it's because I got nowhere.
okay, listen. You need to talk with your attorney about them.
Your Honor, I have.
Do you listen to your attorney as well as you're listening to me? That means not at all.
I got mental issues that just like I'm overwhelmed, very much so, Your Honor. But go ahead.
Thank you. Talk to your attorney about these issues. He'll talk to the prosecutor. They'll see what can possibly be worked out, if anything can be worked out. I'm not reinstating your phone privileges. You violated that condition of bond. That will continue revoked.
Then I'll just continue.
Okay.
Sorry, Judge. If we could have an adjournment so that Ms. Tana and I'm bad with names.
Ms. Rizmersky.
Ms. Rizmersky. I knew the first name. Ms. Rizmersky could consider Ms. Strickland's.
How much time will it take for them?
We only need a week or two, Judge.
A week, please, Your Honor. A week. Let's speed this up, Your Honor. I'm trying to. If you just read my mitigation letter, Your Honor, you find out why.
Ma'am, that's the problem. You keep doing things that your attorney says it's not the appropriate time. When I get that letter into my office, I'm going to tell you I am not going to review it because it's not appropriate for me to see that. If you listen to your attorney, maybe this would go a little bit smoother.
Your Honor, my attorney's not telling me what I need to know. I'm lost.
No, your attorney's not telling you what you want to hear. He's telling you what you need to know. You're just not listening, like you're not listening to me. These matters are adjourned to the 17th, 9 a.m. Bond continued. Thank you.
Thank you, Judge.
Yes, the classic courtroom merry-go-round, where listening is optional personal responsibility, is a foreign concept, and every delay is somehow everyone else's fault. The judge lays it out plain and simple. But nope, let's just ignore that and argue about letters that shouldn't even be read, and of course the attorney is suddenly incompetent because they won't just say what the defendant wants to hear. But sure, let's keep playing the I'm lost card. Because clearly the biggest obstacle here isn't the repeated violations, it's that the legal system just won't bend over backwards fast enough.